Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello again. Hello again. Thank you so much for coming back to hang out with me a little bit more tonight on this lovely Friday. It's lovely Friday. It's Melanie After Dark. You never know what's going to happen. I've just about had it up to here today. Up to here. I really thought today Kelsey Fitzsimmons' hearing was going to be quick. I thought it was going to be maybe an hour. Or maybe we'd be done by 3. We talk about it for an hour, done by 4. Come back at 6, have some time in between, but it never, ever, ever works out like that. What a show that Kelsey Fitzsimmons hearing was today. If you didn't see it, go back and watch it later, because boy, did you miss some fireworks. The district attorney in Essex has outright said, or the ADA, they're not going to prosecute Justin. They're not going to prosecute Justin for the breaking and entering into Kelsey's house and all of the other things that he did, including, but not limited to, list them all for me in the chat. Destroying her security system, destroying her alarm system, destroying the modem, taking her laptop, hacking into her computer, hacking into her bank accounts, her medical records, changing the beneficiary on her pension documents or life insurance, stealing $5,000, having some honeymoon refunded back into his own account, identity theft, wire fraud, $5,000, stealing her passport. It was wild. Go back and watch it, because you won't even believe me if I even try to tell you about it. Right? You won't even believe it. Today is Friday, February 27th, 2026, and happy 227 to those of you who celebrate. Happy 227. To those of you, breaking and entering, all of it. Broke the door down. Just when you thought that story couldn't get any crazier, and trying to figure out why Justin's being protected. We still don't know that. But I think our belief that Justin, Alain, called Justin alien by the district, the ADA, I think his outright refusal to even think about prosecuting Justin, even though he sent it to Middlesex, they said they had a conflict, they couldn't do it, so they got it back, and they decided they're not going to prosecute him. It's a conflict of interest. They can't prosecute him because he's going to be a witness against Kelsey, right? In their case. But this ADA had the cojones to go up. He's not a percipient witness. We don't really. You just can't make it up. You just can't make it up. Happy 227 to everyone who celebrates. I mean, what a day already. Thank you, Mel G, for telling everyone to hit the like button. Hit the like button. It's like wiping your feet on the mat when you come into somebody's house. Also, if you're on replay, hype the stream. I don't know what that really means, but you get 3 hypes a week. So whatever stories you think that I cover that the public should know the most about, give them a little hype. What is 227? 227 is when the infamous Google search was made. Hoss long to die in cold. And it's February 22nd, 27th. 27th. And boy, are the O'Keefes mad. Well, let's see. What have we done today? What have we not done today? I think it's time we should maybe we should pull another empowerment card for the day. Or do we not even pull one this morning? I think we even it wasn't even this morning. The stream started at 1:45. I think we didn't even get done until 5 o'clock. But we have empowerment cards here. I think we should pull one. Even if we did pull one, we'll pull another one because our badass affirmation deck has been finished. So here we go. Pull one from the middle of the deck. And this says, great things never came from comfort zones. There it is. Great things never came from comfort zones. The second you step out of your comfort zone is when all the magic happens. All the magic happens. You know it. I know it. We all know it. People have been trying to shut me up from talking about the Karen Read case since I started covering it in January 2024. It's been over 2 years. I think last time I counted, I had 227 videos on the Karen Read case. Isn't that ironic? Don't you think? Thank you. This is the PM poll. Thank you, Mitchell, for keeping track. I couldn't find it because I didn't put it with the quote from this morning, so I don't know where it went. They've been trying to shut me up since January of 2024. And in the beginning of the I failed shut up class, apparently, as Kathy would say. In the beginning, when they tried to shut me up, it was all of the people that were trying to shut me up, like people who thought that John O'Keefe was hit by a car and people who felt that very strongly that Karen Read was guilty despite science, medicine, and everything else. And now the people that are trying to shut me up or at least disparage me, I mean, I expect it from those people. You know, at this point, it's expected. I'm like Teflon, keep it coming. But now the people that are disparaging me, many of them allegedly are on the Karen Read team. Who are these people? Who are these people? Where are they coming from? And why? Ask yourselves that. It's wild. The call is now coming from inside the house. Crazy, right? Because, apparently, two things can't be true. Apparently, you got to pick sides. I'm going to tell you this right now. I don't care about the Twitter drama. I do not engage on Twitter. And you know that. If you follow me for a long time, you know that I do not engage. I don't play over there. It's a cesspool. Okay? And so I don't even know what's going on most of the time, unless people send it to me, which I ask that you please do not do because I genuinely do not care. I am so busy fighting for justice, not just fighting for Karen Read like I've been doing for over 2 years, but fighting for people like Edric Faust, a Black man who was lynched in Athens County, Georgia, for a 25-year-old cold case murder in which a Black man was never even a suspect. He's just been sentenced to 2 life sentences plus 45 years, and we're not going to shut up until we get justice for Edric Faust. And a lot of other people too, like Kelsey Fitzsimmons. We're not going to shut up about that either. We covered Brian Camp's trial, which nobody even heard of. He was a young kid in Hampshire County who protected his family, his 2 little girls, and his fiance when a home intruder broke into his house and tried to kill them. He wound up killing the home intruder, and he was on trial. We saw him acquitted, so that was really great. We watched Penny McGee be acquitted after she was tried for manslaughter in Judge Beverly Canone's courtroom in Norfolk County because she had an argument with her estranged ex-husband, a verbal argument, and he dropped dead of a heart attack. She was on trial for manslaughter. We saw Beverly Canone acquit her on a bench trial We're fighting for Aaron Spencer, who killed his 13, 14, 15-year-old daughter's rapist after a Lonoke County, Arkansas judge allowed her rapist out on $2,500 bail, which enabled him to further groom her, kidnap her from her bedroom, rape her some more, and then when her dad went out looking for her, found her with him. And if it wasn't for Aaron Spencer, his daughter likely would not have made it home alive that night. She was the only witness in the upcoming trial for that man, Michael Fossler, that pedo, who coincidentally at one time was a police chief in Indiana. Sarah Grace Patrick, who allegedly they have a mountain of evidence against over there in, where's she? She's in another part of Georgia, right? And the media has already painted her guilty because she went to TikTok with her feelings. How old is Sarah Grace? 15 when the murder of her parents happened? There's a mountain of evidence, allegedly. But what they fail to tell you is that her mom and her stepdad were held at gunpoint within like a week before the murders, and there's a witness to that. They were shot to death, and apparently there's mountains of evidence, but nobody's seen any of that yet. So when they try and rage bait me into getting involved in their nonsense on other platforms that I don't engage in, it's a losing battle for you because I really don't care. I really don't care. I got other things to do. Okay. But I know you're watching, and I know you're going to clip whatever I say and twist it into something. You know, you'll take some pictures of me and post them on there like anybody cares. And thank you for the views. But if you hate me so much, why do you keep watching my stuff? Why are you so obsessed with me? Why are you so obsessed with me? Get a job. Get a hobby. Find some friends. Like real life friends, not just Twitter friends. It's insane. People are insane. Many of them are watching right now. They won't admit it, but they do. They watch. They're obsessed. Great things never come from comfort zones. That's how that rant started, and it's the truth. Step outside your comfort zone. And for those of you who choose to get out there and defend me, why, thank you very much. I appreciate it. But I don't even really know what it is. Lindsay Clancy. Other people. There's a lot of people out there who deserve attention. And you got to spread it around, right? All right. Well. After that 13-minute rant, there is some good news today in the Karen Reed land. Can you believe we're still doing this? We're still doing this. Was it only yesterday that we watched the hearing on Miles King and Karen Reed and her team were there in front of Judge Doolin? Was it only yesterday? Because Judge Doolin took it under advisement about whether or not Karen Reed and her team were going to get Proctor's total phone extraction just yesterday. Karen Reed was there because we watched the after court comments about it. And Judge Doolin took it under advisement, but it's also important to point out that the O'Keefes were fighting for that phone extraction too. So it's like, you can't use it as a shield and a sword, trolls. You can't be out there saying Karen Reed shouldn't get his private text messages. It's an invasion of his privacy. The O'Keefes want it too. So if you don't think that Karen Reed should get it, then you shouldn't think that the O'Keefes should get it either, right? In their civil case, but it doesn't make any sense. Judge Doolin has issued his ruling quickly. More quickly than any other judge that we've seen in the Commonwealth who took something under advisement. And they're getting everything. They're getting everything. Here's where it's a little wonky. The motion was made in the Miles King case. Commonwealth versus Miles King and the 3 companion cases, because everybody's looking for Proctor's phone extraction, the total phone extraction that was done by the Commonwealth all the way back in August of 2025. And even though Proctor's attorney said, well, we'll give you the phone, but you're not going to find anything because everything auto deletes after 30 days now since Proctor lost his phone or destroyed his phone or whatever, going back to February of 2024. But they did. They got the phone, they extracted it, and they got something like 13 years worth of data. They've been fighting for it because they wanted in Karen Reed's civil case. But the problem is, when they made a motion or they subpoenaed Proctor in the civil case to give Karen Reed the phone extraction that he got as part of discovery in these cases, after which his union attorney dropped him, they pulled his appeal, you know the story. Proctor said, I'm not going to give it to you. I lost my phone. He lost his phone again. He lost his phone between August of 2025 when he got it back and the time that Karen Reed's attorneys served him with a subpoena to hand it over. He lost it. So they had to go back into the Miles King case to ask the judge to permit the district attorney in Norfolk County to give them the entire phone extraction of Proctor. And then we read the papers on that. I don't know. Was it yesterday? The days are blending together. And Proctor's attorneys actually had the cojones to say, well, why don't you just, the Commonwealth shouldn't give it to you. You should just make a demand of Proctor to give it to you. And Proctor doesn't have it, he said. And he also destroyed his phone or lost it or whatever in a military base on a dumpster. I don't know. No idea. But Judge Doolin did issue his ruling, and I believe it just came out this morning. So here it is for you. Kind of hot off the press. And this is in the Commonwealth versus Miles King case. And this is an order regarding information derived from a former state police trooper's personal phone previously obtained through court order. That was fast, right? I know. I think it's a record. Pursuant to Massachusetts Rule of Criminal Procedure 14.2G, it is hereby ordered as follows. Counsel for the parties in O'Keefe et al. Versus Karen Reed, Waterfall, and C.F. McCarthy's may receive one copy of the files from Michael Proctor's cell phone determined to be bias information previously produced to certain criminal defendants in Norfolk Superior Court. Phone determined to be discoverable under Rule 14, bias material. That means both parties, counsel for all parties are going to get it. The O'Keefe's, Karen Reed's team, C.F. McCarthy's, and Waterfall. I mean, that's what it says. Counsel for the parties. The Commonwealth also may produce files related to Karen Reed or the investigation of the death of John O'Keefe, okay? That doesn't seem to be limited to just Proctor's phone. Well, yeah, I guess it is because that's what the order says. So what that would mean is all of the stuff, I guess, that the feds turned over. Or any files related to Karen Reed or the investigation of the death of John O'Keefe? Unclear. Something like 50. Yeah, it was 50,000 pages, Mitchell. Very good. You get a gold star. 50,000 pages. Disclosure of the materials shall be limited to counsel, associate attorneys, paralegals, administrative assistants, investigators, and experts assisting counsel of record in O'Keefe et al. Versus CNC Hospitality et al. That is the Plymouth Superior Court wrongful death lawsuit by the O'Keefes against Karen Reed, Waterfall, McCarthy's. Counsel shall not show or provide the materials produced pursuant to this order to anyone other than those persons described above, except counsel may show but not give the material to the parties. It means Karen Reed could look at it, but she can't have a copy. And may show the materials to any subject of a deposition. We've learned they're going to have at least 41 depositions, and I think they've all got to be done by the end of the summer. And that means that they're going to be working on little else. How are any of these attorneys going to have time to work on any of their other cases? Their other clients are all going to be, I don't know. I don't know how big Mark Diller's firm is, to be honest. They're going to be real busy doing depositions constantly. The materials shall not be disseminated outside the above referenced litigation and in accordance with the referenced and incorporated confidentiality agreement in O'Keefe. The Commonwealth shall be permitted to separately redact an SA victim's name. That's all they're redacting. That's all that they're allowed to redact is one SA victim's name. And Mark Diller called into this hearing because maybe he didn't know that it was going on. And Aaron Rosenberg, I think, argued for Karen. I'm conflating all of these hearings in my head because they're just popping up every day. But they're getting everything. It didn't say redact the photos of the intimate body parts of women or the intimate photos of the women, the nudes, as it were. 13 years worth of data. Karma knows your address. What do I say? Karma knows your address. That is dated yesterday, 2/26/26. So he even issued this order probably right after he got off the bench yesterday. He's giving them what they want. Both sides. Both sides. Didn't they also argue that they shouldn't be allowed? Didn't they also argue that Karen Reed's team shouldn't be allowed to quote any of it in their papers? And Doolin was like, why not? Because he didn't order that. I haven't seen a ruling on Karen's phones, no. But what I did see, and what is closely connected to the release of Karen's phones, because she wants to get them back, these are two cell phones that were seized by law enforcement in January of 2024, right? January of 2024. I think it was Tully. Was it Tully and Proctor who came to her house to seize her phones? Because they really, really, really wanted to charge Karen Reed with witness intimidation for conspiracy to commit witness intimidation with Aiden Carney. And so they went and seized her phones back in January of 2024. They tried to indict Karen and Aiden by convening a grand jury in March of 2024. This is before Karen Reed's first trial. I do believe that Tully was the only witness at the grand jury, and they did not extract Karen's phones or search them at that time, even though they had them since January 2024. And they claim to date that they still have not extracted any information from Karen's phones because they don't have the passwords. And they're trying to force Karen to give up her passwords. And even though Judge Cannoni has ordered the return of Karen's property because she was acquitted, she got her car back and the phones that were originally seized in 2022, but they won't give these phones back because Cosgrove has self-appointed himself special prosecutor of Karen Reed, and now he's claiming that he shouldn't have to give them back because there's a case pending before the SJC that might make new law, and then maybe he'll have to get them back, maybe he won't. Fanning and Tully. It was Fanning and Tully? Oh, okay. Fanning and Tully, who went to her house and seized her phones. But they've been hanging on to him all this time, over 2 years, and they've done nothing with him. And so hitting the docket, well, it says they were this was filed on the 23rd. But they just somehow ended up in my inbox today. There's an emergency motion for a temporary restraining order made by the O'Keefes to try and prevent Karen Read getting her phones back. So let's take a look at that. It was BUKHEKIK, Fanning, and Garino. I don't know how you guys keep this all straight in your heads. I really don't. Because my brain is like mush after this. All right, let's take a look. And boy, was this written for the media or what? Many of you think they might have already looked at her phones. They might have tampered with her phones. Maybe that's why they don't give them back, because Karen's expert will be able to figure it out. It's all just a guess, but many people think that. Let's take a look. This is a cold read for me, so show me some grace. I haven't even had a chance to finish this today because we were on Kelsey all day. What do we have here? Now, remember, in civil court, it is much different than criminal court. And in civil court, what happens is the motions are not filed the way we do things here in New York. In New York, you file a motion, you file it with the court. The defendant files their opposition, they file it with the court. In Massachusetts, the motion is not filed with the court until all of the replies are received. And then somehow it gets submitted as one package. And so that's what happened here. So you see the date on this motion is earlier. And the filing date here up on the left-hand corner is 2/23/26. But this was served on the other side. It doesn't even say, it's not even dated. It's not even dated. All right, maybe we'll find it. Maybe we won't. But all of the papers were submitted on the 23rd to the court. And so this is in the O'Keefe versus Karen Read, Waterfall, and CF McCarthy's matter, pending in Plymouth Superior Court. And this is entitled Plaintiff's Emergency Motion for Temporary Restraining Order pursuant to Rule 65 to prevent release of evidence. Footnote 1. Because some exhibits are in video format, all referenced exhibits can be found here. Oh, copy link and paste in browser. Oh, I don't know if I can even copy the link and paste it in my browser, but I mean, we might have to look at the exhibits at some point. Oh, uh-oh. This link has been removed, it says. It says this link has been removed. If anybody can access it, let me know. And the first line of this motion reads as follows, quote, italics, I'm dead. I'm effing dead. Do you have any clue what's on that phone that they took? End quote. I've never seen a quote open a motion like that, but that's for emphasis and media purposes. And if you've been following this case, you know what that is. Karen Read apparently said that on the phone when she was talking to Aidan Carney, and somebody got a hold of that recording and released it to, I don't know who, Karen's attorneys, Karen, sometime around the Wilbur show in September, I think. Now come the plaintiffs and respectfully request this court issue an order restraining defendant Karen Read from taking possession of cell phones in the custody of the Norfolk DA's office before plaintiffs have had an opportunity to digitally image the phones so a full record of the phones is maintained and communications and data reasonably calculated to lead to discovery of admissible evidence are preserved. They're like, please, 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 do not give Karen Read her phones. Give them to us first so that we can extract them. Plaintiffs request a temporary restraining order to maintain the status quo pending a formal hearing on the matter. As grounds, therefore, plaintiffs respectfully state as follows. Relevant background. Well, Karen Reed was charged criminally in connection with the January 2022 death of Boston police officer John O'Keefe. Investigators seized a cell phone belonging to Reed as part of the murder investigation. At some point thereafter, police seized other cellular phones belonging to Reed in connection with prosecuting blogger Aidan Carney, known as Turtle Boy, for witness and juror intimidation in Reed's criminal case. Really? At some point thereafter? Do you really not know when those phones were seized? How do we know when the phones were seized and they don't? The devices remained in government custody throughout Reed's 2024 trial and 2025 retrial. In late 2025, the Norfolk DA's office, in connection with the Carney investigation, sought authorization to search Reed's phones for relevant evidence. Well, but was it in connection with the Carney investigation? Or was it in connection with trying to charge Karen Reed with anything to pin something on the girl so they didn't look as foolish as they do? Because they already have Carney's extractions, right? And so that's a little disingenuous. In February 2026, a Norfolk Superior Court judge denied Norfolk DA's office request to search the phones with its decision under seal. But note 2, Norfolk Superior Court criminal docket number, and here's where it gets wonky, 2482 SW0004. If anybody can find that in mass courts, let me know. It does not exist. That is the search warrant number. It is not a criminal docket number. But just to prove to you that I'm right, because I'm pretty sure I am, but you know, let's all do our due diligence. I'm going to search it up for you in real time. Okay. They say Norfolk Superior Court criminal docket number. Okay. 2482 SW 0004. Okay. Here's what comes up when you search that case number. No records found. If anybody, I'm going to show you because we like receipts here, has been able to locate this docket number, you will be the only one. Because it just doesn't exist. Here it is. Get myself out of the way. Superior Court, Norfolk County, case number 2482 SW0004. It does not exist. Okay. And they put it in their papers. Is it a hidden file? Is it a super secret file? No, it's not a typo. It's under a search warrant number. Trust me. I have searched this every way possible with a CR in there. You want to do it with a CR? We'll do it with a CR. Because that's what criminal cases usually are. It's also not filed under Aidan Carney's numbers. No records found. There it is with a CR. Must have been a clerical error. A scrivener's error. I'm not going to waste all my time looking for it. I can tell you I've looked for it a million times. It doesn't exist. If anybody can find it, you win the prize. You win the prize. I'll send you a sweatshirt. If you can find whatever case number these papers are filed under, I'll send you a sweatshirt. Doesn't exist. Again, maybe this, maybe that. No, that's not. Go ahead and find it. Find it and report back to me. It doesn't exist. Back to the babies. On Thursday, February 19th, 2026, Reed sought an immediate return of her cellular phones in order to prevent the immediate and irreparable loss of evidence critical to plaintiff's civil claims. We filed instant motion. Legal standard. A temporary restraining order may be granted without written or oral notice to the adverse party or his attorney only if it clearly appears from specific facts shown by affidavit or by the verified complaint that immediate and irreparable injury, loss, or damage will result to the applicant, before the adverse party or his attorney can be heard in opposition, according to Civil Procedure Rule 65. The temporary restraining order serves principally to maintain the status quo pending a hearing. Quote, the destruction of relevant evidence has a pernicious effect on the truth-finding function of our courts. Well, nobody's been accused of destroying evidence except for PROCTOR, Brian Higgins, and Brian Albert. Maybe BUKHEKIK for inverting the video, or Colleen Crawford, or whoever did that. Preventing spoliation and preserving evidence necessary to adjudicate claims are within the court's inherent powers that are essential to the function of the judicial department, to the maintenance of its authority, or to its capacity to decide cases. Argument. In order to ensure the preservation of admittedly critical evidence and to prevent irreparable harm to plaintiffs' ability to fully and fairly prepare their case, plaintiffs seek an emergency order of this court temporarily restraining defendant Reed from taking possession of her cell phones from the Norfolk DA's office to allow the plaintiffs an opportunity to be heard regarding the need to forensically image the contents of Reed's phones before such devices are returned to Reed. And these phones may very well be discoverable under the rules of the Civil Court of Massachusetts. The contents of Reed's cell phones are materially relevant to plaintiffs' infliction of emotional distress allegations. This court has already endorsed a plausible claim against Reed for pushing a false narrative through the media, notably Aidan Carney, Turtle Boy Bad, and for pitting the Reeds against the O'Keefe family. Who pitted the Reeds against the O'Keefe family? Footnote 3. Which reads, on or about October 3rd, 2025, Judge O'Shea denied Reed's motion to dismiss plaintiff's claims for reckless and or intentional infliction of emotional distress, relying in part on the contents of an affidavit of State Trooper Brian Tully seeking an application for a search warrant to seize Reed's mobile devices. This court noted that Carney, Turtle Boy, unquestionably took extensive efforts in publicizing information regarding the charges against Reed, and the affidavit describes Reed acting in concert with some of those efforts. Notably, Carney stated that the time had, quote, expired for, quote, going after the O'Keefe family, and that the O'Keefe family was involved in a cover-up regarding JJ's death. Okay, well, that was the search warrant to seize Reed's phones, which he obtained, and he actually did seize the phones, but he never searched them. And I think that the new case that is currently pending before the SJC has to do with the delay in time from the time you obtain a defendant's cell phones until the time that you actually decide to search them. And if the time is unreasonable, you can correct me if I'm wrong, they don't get to just search them whenever they want to hang on to them until the statute of limitations is about to expire on whatever alleged crime they allegedly want to prosecute someone with. They would be able to hold on to things for as long as they want. And that's not the way the law works. Oh, Slim and Bones. Yeah. You can email me. My email's in the show notes below the video. You got to find it. Close out your chat. It is not disputed that Reed was feeding information to Carney to shape the public narrative. In an interview with HBO, Reed stated, quote, remind me which documentary was on HBO? Was there a documentary on HBO? I remember there was like Dateline, Nightline. What did you send? That's 85 pages. You sent what? Hold on. I'll look when I have a break. In an interview with HBO, Reed stated, quote, Nathan only started talking to Turtle Boy after Turtle Boy got involved. John was always a fan, and John, like one of my conduits early on. Wait, John O'Keefe was always a fan of Turtle Boy? I don't know if I knew that. The lawyers told me that we could share anything with him, Carney, as long as it was public and not for me to do it directly to go through a third party. There was one on HBO. Investigation Discovery. Oh, that was the Discovery ID one? You saw it on HBO? Body in the Snow is available on HBO now. It was on, right, it was on Discovery ID first, right? It had nothing to do with HBO. They didn't produce it. It was Discovery ID. Okay, cool. Cool. It's confusing. That was the protocol for a little while, and then I started to get nervous about who I was using for a third party because I started to trust Turtle Boy to an extent, but the information I'm giving him is valuable, and I need to trust the middleman. I didn't want to have any of my close friends to do it because I didn't want to put them in that spot, so I eventually just started sending things to him directly. But I would tell him I'd give him some backstory. Relaying it through someone who's had a few glasses of wine to have it relate to Turtle Boy, I thought, I've only got so much patience here. And then this is bolded. I've just got to talk to this kid directly. And then we started talking about the case probably once a day, almost every day, 5 to 6 days per week. It was a little quid pro quo. He was getting tips that were better than a lot of the tips we were getting, and I was helping him getting up to speed on what he had missed from the previous year and a half. I don't have any shame. I haven't denied it. I'll tell anybody how often. It's in the phone records. I talked to him almost every day. This case has been massive for him, and it's my entire life. So yeah, we talk about Jen McCabe and Michael Proctor and what's in the latest discovery. And what do you guys think you're going to do next? We had these conversations. And that is Exhibit A. I don't know. Somebody's saying Body in the Snow was on Netflix. I don't know. But is that what you think that they're talking about? Okay. And again, it's not illegal or improper for any defendant to speak to any journalist that they want to. There's nothing wrong with that. It's done all the time. When Carney was investigated criminally, police seized Reed's phones. These phones are the subject of this motion. Well, here's the thing. When Carney was investigated criminally, that was way before the seizure of Karen Reed's phones. Tell me, I'm watching the chat. Tell me if I'm wrong. Karen Reed's phones were seized in January of 2024. Wasn't Turtle Boy in jail at that point? Was Turtle Boy in jail in January of 2024? And so this is not during the investigation of Carney. He had already been indicted, right? He was already facing a whole bunch of felony and witness intimidation charges. And then when they did the setup, when they did the bump, as they call it in the Donna Adelson case, and got him to violate his bail conditions around Christmas time, he was sent to jail at the Norfolk County Pokey. So they seized Reed's phones to try and prosecute Reed, not Aidan Carney. Aidan Carney was in jail. Plaintiffs have a good faith basis to believe that the data contained in those phones, emails, texts, internet usage, application usage, etc., will confirm that Reed was communicating her narrative either directly or indirectly or through intermediaries to Carney. Carney's publications and videos have mirrored the Reed's team's narrative and have publicly attacked the O'Keefe family with information transmitted to him by Reed. Unlike the Norfolk DA's office, plaintiffs need only show their request for these communications is reasonably calculated to lead to the discovery of admissible evidence, a markedly lower standard. That is true. That burden is met here. For example, these exchanges from April 2023 are just a snapshot into how Karen Reed was helping direct this public narrative through Carney. On April 23rd, 2023, at 11:03 a.m., Carney notified Reed through an intermediary, Natalie Wywicki, or Natalie the German, that he was writing a blog about Sarah Levinson, a Commonwealth witness. Exhibit B. Through the intermediary, Reed responded, Reed responded through the intermediary, Natalie, tell him Proctor likely intentionally spelled her, Levinson, and Julie Nagel's names wrong. Her name is Sarah with an H, not Sarah. Carney asked why spell the names wrong, to which Reed, through the intermediary, responded, to hide their identities from us, make them tough for the defense or public to track. Carney responded, it's up. The next day, April 24th, Carney posted a blog titled, Canton Cover-Up Part 9, Woman in House Where John O'Keefe Was Murdered is Beth Israel, Milton nurse Sarah Levinson. Name was intentionally misspelled by Trooper Proctor on the police report. Also on April 29th, 2023, Reed, through intermediary Natalie, texted Carney. Well, I mean, why don't you just name the nephew in here without redacting his name? Patrick Furbush is wearing a jersey with his uncle's murderers on it. Kerry Roberts is an effing C word. Always has been. Tell Turtle Boy, great job with the geofence. And then this is in bold. Please, if you agree, post something to the supporters of the Furbush children. These supporters can no longer pretend to care what happens to those kids. Text me from Signal. Check your signal. Check your signal. Check your signal. The next day on April 30th, 2023, Carney posted a blog, Canton Cover-Up Part 16, writing, let's be clear, you cannot claim to support the Furbush children, John's niece and nephew, as people like Kerry Roberts do if you are actively covering for their killers. Kerry Roberts is not interested in protecting or shielding this young boy. She's exploiting him on social media for likes as he parades around in an Albert family shirt. Exhibit E. Additionally, plaintiffs have good reason to believe the contents of Reed's phones may undermine Reed's third-party culprit affirmative defense and related under oath statements made in answering plaintiffs' interrogatories. For example, Reed stated in response to interrogatory number 2, I do not know which specific individual or individuals within the house fatally wounded Mr. O'Keefe. However, on May 6, 2023, Reed, through Natalie, texted, quote, tell him the body was moved. Tell him I can't be more specific because this is the key witness no one knows about. It's not a party goer. Not anyone who was at the party. Exhibit F. Later, she texted Aiden. She texted, quote, Aiden, I'm telling you, we know for sure when and whom. We know for sure when and by whom the body was planted. Exhibit F. This purported knowledge was omitted from Reed's under oath response, even though the interrogatory called for all facts forming Reed's third-party affirmative defense. In July of 2025, plaintiffs propounded discovery and preservation orders upon Reed and a subpoena upon Norfolk DA's office requesting the extractions from these phones. None have been provided to date, and no privilege log was provided. Counsel for defendant Reed confirmed that no information from Reed's cell phones was included in the 900,000 plus page document dump provided on November 20th, 2025 and December 2nd of 2025. Should the cell phones be returned to Reed and their contents altered, plaintiffs will suffer irreparable prejudice in prosecuting their emotional distress claims. Conversely, Reed's claim that she needs the phones returned urgently stands in contradiction to her speaking to the press from the courthouse steps using a different personal or cell phone. What? Conversely, Reed's claim that she needs the phones returned urgently stands in contradiction to her speaking to the press from the courthouse steps using a different personal cell phone just this past Thursday, February 19th. I'm sorry, did you think she wasn't going to obtain a new phone after they took hers in January 2024? Do you think she should be without a phone? And so therefore, because she now has a phone, she doesn't urgently need them returned to her. She needs them urgently returned to her so she can have her expert examine them to see if the Commonwealth tampered with them while they were in their possession. Hello? It goes to the root of her case in which she sued everybody for violation of her civil rights. Exhibit H. I bet that's a picture of Karen Reed holding a different cell phone. But we'll see. Plaintiffs further have a good faith basis to believe that Reed may alter or destroy the cell phone contents should they be returned to her before plaintiffs can preserve all data contained on the devices. Oh, you mean kind of like Proctor did? When police first seized one of the devices on January 24th of 2024, okay, so you know when they were seized, Reed Factory reset the device, wiping all data and information from it, according to Exhibit I. Recently, audio from a phone call between Carney and Reed was leaked, during which Reed stated, quote, and this is in bold, "I'm dead, I'm effing dead. Do you have any clue what's on the phone that they took?" Exhibit J. Reed's own admission supports plaintiff's belief that the subject's cell phone contains discoverable information materially relevant to the plaintiff's claims and harmful to Reed. Reed sought relief through the criminal court without notifying plaintiff's counsel, even though the cell phones are integral components of this case. Plaintiffs only received notice via social media. The timing of Reed's February 19th motion also raises suspicion, considering this court on February 12th ordered the parties to convene about a plan for exchanging electronically stored information and to file the same by March 3rd. Once the cell phones leave secure evidence holding. Oh my God, the funniest part of that sentence is that they think that there's secure evidence holding in Norfolk County DA's office. That's hilarious. Are you new here? Do you think there's any chain of custody on those phones? Once the cell phones leave secure evidence holding, even innocent use of the devices will overwrite crucial information and metadata contained oh, come on. Nothing. You don't need metadata in the Commonwealth. Are you new here? You don't need metadata in the Commonwealth. It's hilarious. Oh, I bet you ruined the day you ever took this case on contingency, huh? Plaintiffs therefore seek a temporary restraining order preventing Reed from taking possession of her cell phones until plaintiffs have the benefit of forensically preserving and imaging those devices. Plaintiffs are willing to engage a court-approved third party, i.e. a taint team comprised of a judge and forensic examiner agreed to by the defense to review and log any potentially privileged attorney communications. Well, isn't that kind of you? Why don't you throw more good money after bad as a plaintiff's lawyer? Judge Doolin directed plaintiffs to file their opposition to Reed's motion for return of property in the criminal case on Monday, February 23rd of 2026. Wonder if they did that. Today's the 27th. Plaintiffs seek this court's intervention in tandem with such opposition. Wherefore, plaintiffs respectfully request that this court issue a temporary order restraining defending Karen Reed, from taking possession of cellular phones in the custody of the Norfolk District Attorney's Office, pending a formal hearing on plaintiff's request for a neutral third party to forensically preserve all communications and data contained on those devices. Plaintiffs respectfully request a hearing on this matter. XOXO. The plaintiffs, all the O'Keefes and Kaylee, by Mark Diller, Esquire. You know what? I just thought of something. Would the defense be entitled to an extraction of Peggy O'Keefe's cell phone? Because wouldn't the contents of Peggy O'Keefe's cell phone be relevant to show that Haas defendants, including perhaps Jennifer McCabe, were communicating with Peggy O'Keefe immediately and incessantly after the murder of John O'Keefe? I mean, I could see where that could be completely relevant to Karen's case. And as you pointed out, Mr. Diller, and I agreed with you on this, the burden in civil court discovery is whether you only need to show whether the request for these communications is reasonably calculated to lead to the discovery of admissible evidence. I mean, couldn't you make the same argument for Paul O'Keefe's cell phone too? Was he communicating with Proctor, Jen McCabe? What were they being told about the investigation? I mean, they're parties to this action. I mean, they're not parties to the federal court action. So they'd have to get them in this action, right? I wonder if Mrs. O'Keefe has lost her cell phone since, 2022. I don't know. I'm just saying. Spitballing with you. Kaylee's phone could also become relevant. Yes. And you remember one of the last shows that we did, we compared the plaintiff's complaint in this action and their allegations against what Karen did to Kaylee with Kaylee's initial statements to police. And Kaylee's, I don't know if we got to Kaylee's trial testimony, but her initial statements to the police had nothing in there regarding Karen saying, John's dead. John got hit by a plow. I might have hit him. Maybe I hit him. It's not in there. And it could be very detrimental to Kaylee's claims, at least. I don't know. Just thought. Exhibit A, which is this link, is apparently, I don't know if it exists or not. You can try it yourselves. Here's Exhibit B. And what this purports to be, screenshots between Turtle Boy and someone. Don't know if it was Natalie. Let's see. Wait, Exhibit B. All right, well, let's go back and see what they say it is. Exhibit B. So these are messages between Natalie, the intermediary, and Turtle Boy. And so these would be from Natalie's phone because it's got Turtle Boy at the top. And so Natalie would be on the right. Did Natalie give her phone up for extraction? I don't know. These aren't from Aiden's phones. This is from Natalie's perspective. April 24th, 2023. Aiden says, doing a quick blurb about Sarah Levinson. Did Jen McCabe drive her home? Natalie says, let me check my notes. I'm at my laptop. Aiden says it was. I got it. Natalie says, tell him Proctor likely intentionally spelled her and Julie Nagel's names wrong. Jen did drive her home. And there's a PDF of an MSB report interview. Can't see what it is. Natalie says her name is Sarah with an H, not Sarah. Nagel and Levinson are also both MIA on social media as of today. Aiden did a double exclamation point to the one about Sarah, not Sarah. Aiden says, has she testified in front of a grand jury? Natalie says, nope. Why spell the names wrong? Aiden goes on to say, why spell the names wrong? In case people Google. Natalie says, it's hard to read. To hide their identities, make them tough for the defense or the public to track. Aiden says it's up. They're protecting everyone in that house, including her. A healthcare worker letting a man die in front of her and then lying to police to cover for his killers. Her friend's father. And then we move to Exhibit C, which is the Turtle Boy article. Canton cover-up, Part 9. Woman in house where John O'Keefe was murdered is Beth Israel Milton nurse Sarah Levinson. Name was intentionally misspelled by Trooper Proctor on the police report. And it's part of it is blocked by what appears to be a screenshot of an ad in front of maybe a pop-up on Aiden's website. But if you'd like to read that, you can just Google that. Canton cover up Part 9. Well, let's see. We could read through it, but there's a whole part of it that's blocked. On the night when John O'Keefe was blank, and then we can't read it because there's a pop-up in front of it. Jennifer McCabe was in charge of getting the young people out of the house who didn't have rides, including Nagel and Levinson, who were dropped off at their homes by McCabe around 2 a.m. And then it goes on to talk about, according to Ms. McCabe's initial interview with Trooper Proctor on January 29th, this looks like it's pulled from a police report. And so I'll leave it here. Or this could be pulled from a motion in the Karen Reed case. I'm not quite sure, but I don't know if it's part of the article. And there's a LinkedIn page for Sarah Levinson. What's not yet been pointed out is that college graduate is a nurse at Beth Israel. How could Sarah Levinson not have known that a Boston police officer died inside the house she was in? How could she not have heard the struggle? Again, you can Google this article if you want to read it. And then there's Michael Proctor's interview of Sarah Levinson, where he spells it S-A-R-A. Exhibit D. Other text messages from somebody else's POV because it's got Turtle Boy again at the top. Some of these we just read in the motion. And because I want to get through all of these papers tonight, I'm going to leave them here. So if you like, you can screenshot them. 4/29/23 is the date allegedly that they were sent. Some of them 4/30/2023. Check your signal. And then Exhibit E. Canton cover up. Part 16. Kerry Roberts posts Facebook pictures showing John O'Keefe's nephew and advertising Albert Pizza Shop and Bar where he met his murderers. Pop-ups again. And you can Google that article if you want to read it yourself, because I have no patience for incomplete things with, pop-ups in front of them. Here's a picture, though, of Colin Albert, and I think that's Brian Albert with their fist pump. Exhibit F. More messages between Turtle Boy and Natalie. Turtle Boy says, enjoy the show. It doesn't say when this is. Natalie says, I'm at dinner. I haven't listened, but I will when I get home. Let me ask Karen. Yes, all the shows are good. And then there's a ha-ha. Turtle Boy says, LOL, man, you're a good friend. Natalie says, but tell him the body was moved. Tell him to think about what was happening that night / other potential non-Albert witnesses. I feel like Mark felt, but tell him I can't be more specific because this is a key witness that no one knows about. Think, Aiden, think. Deep throat, says Turtle Boy. Drive by Fairview, Aiden. I promise you will be shocked at how small that front yard is in person. Would be tough to plant a body without being seen. Turtle Boy says, small enough for John to run to the front door. Natalie says, not public, but you can share with Aiden. Phone was not signaling for most of the night. Best guess is airplane mode. Turtle Boy says, how did they know? Natalie says, Aiden, I'm telling you, we know for sure when and by whom the body was planted. There's a specific reason he was placed exactly where he was. Don't believe everything you're reading about Levinson. If Proctor is lying about some things, he can lie about anything. Sarah was not called before the grand jury to spare her from perjury, so all we have is Proctor's synopsis of her interview. The boy says, I believe her. She's been right about everything so far. Natalie says, it's not a party goer, not anyone who was at the party. Me asking, was Higgins a party goer? And then we get to Exhibit G. That is an email chain that we probably have to read from bottom up. About their meet and confers going back to July of 2025. In short, Mark Diller, the attorney for the O'Keefes, in the O'Keefe versus Reed civil wrongful death lawsuit, really, really, really don't want Karen Reed to get a hold of her phone because their allegation is she'll destroy it. And then all of that really relevant information for our civil case will be destroyed. Thank you, Ellen, for your 10. Don't go anywhere because we have more. There's more papers. There's a reply from Karen's team, and then there's a response. I mean, there's an opposition from Karen's team, and then there's a reply from Mark Diller. Thanks, Ellen, for your 10. Appreciate you. Thank you, Rattlesnake, for your Canadian super sticker. I appreciate you so much. Kay Bella said we needed that Mariah song Obsessed on the show. Iceman says, hey, Mel, maybe a dumb question, but why do civil trials take so long? Like after depots, they don't go to trial or no? And there's like, because there's such a backlog of civil cases and there's no right to a speedy trial in civil court. So they linger and linger and linger and then linger. But it seems like this judge wants to push it along, but I don't know. Every deposition that they do, in my opinion, is going to lead to more depositions and more discovery. And there's so many parties involved here. They've already said they're going to do at least 41 depositions. So they just take forever. Thanks, Iceman, for your 5. Not a dumb question. Thank you, Karen. I don't know what it was that you sent, but I'll take a look. Oh, please. Well, I mean, you guys are sending me documents, but not the actual like case folder where all of the documents can be found. No, I don't need the search warrant. I already have the search warrant. We've got that. That's a lot of pages. But what I'm looking for is the actual docket number that these papers can be found in. They should all be there somewhere, but they're just not. Like, sending me documents is great, and they've got this docket number on them, but you just can't access them. That's the problem. So, like, what you're sending me is just motion papers, not the actual court file where all of the papers are filed under a certain case number. You see what I'm saying? The hidden case number, it doesn't exist. It just doesn't exist. Okay, moving on. Let's go to the opposition now. The opposition from, oh, look at this. Fire pilot's wife gifted 20 memberships. Thank you. Thank you. Welcome to the 20 new members. Enjoy your special emojis. Thank you, fire pilot's wife. And welcome to all, however many thousand of you that are watching that are not following the Corey Richins trial. Thanks for coming. All right, next up, we have the opposition to the motion that we just read. So we just come on over. Let's see what Karen Reed's team has to say about this. And so remember, well, this was filed on 2/25/26. What was the other one filed on? I thought it said the 23rd. Maybe they just didn't docket them timely, and this was filed the 27th. So I don't know. I don't know why it was done this way. Usually the packet gets filed all at the same time. Okay, here we go. Thank you, Fire Pilot's wife. You're super generous and amazing, and I love you with all of my heart. Love you with all of my heart. All right, here we go. This is the defendant's opposition, defendant Karen Reed's opposition to the motion for the temporary restraining order. Opposition to plaintiff's emergency motion for a TRO, temporary restraining order. Rather than heed the court's urging to move discovery forward in this case by scheduling and taking depositions, plaintiffs now file a fundamentally baseless emergency, in air quotes. We learned a lot about air quotes today, motion relating to defendant Karen Reed's phone that the government has held for more than 2 years and which is subject to a written objection Reed served on plaintiffs 4 months ago that plaintiffs have never discussed with Reed's counsel, let alone challenged. In their latest attempt to use this proceeding to inject scurrilous allegations into the public record, plaintiffs disregard Superior Court Rule 9C and the Rules of Civil Procedure 34 and 65 and ask this court to restrain a separate criminal session of the Superior Court and impose drastic sanctions in the form of a forced full forensic examination of Reed's entire phones without any of the prerequisite factual foundation Massachusetts courts universally require before ordering such an extreme remedy. The requested relief is also contrary to an express prior agreement between counsel and plaintiffs have not presented and cannot present any evidence whatsoever of discovery malfeasance by Reed that would support such relief. For this and other reasons as set forth below, the court should deny plaintiff's motion. First, the motion fails based on the very Rule 65A, a standard the plaintiff set forth at the outset of their motion. Legal standard, a temporary restraining order may be granted without written or oral notice to the adverse party or his attorney only if it clearly appears from specific facts shown by affidavit or by the verified complaint that immediate and irreparable injury, loss, or damage will result. Plaintiffs have not filed an affidavit in support of this motion, and their complaint in this case is unverified. Oh, that means that an unverified complaint is one that is signed by an attorney instead of the actual plaintiffs. The rules do not permit a temporary restraining order or a preliminary injunction on this record. Oh, thanks, Strissa, for gifting 5 memberships. You're amazing. Thank you. Welcome. Even if the plaintiffs had submitted their evidence in support of the motion in an acceptable form, there is no basis whatsoever for the court to award the drastic remedy of a restraining order in order to prevent the destruction of evidence or preserve evidence necessary to adjudicate claims in this case. There's nothing to suggest plaintiffs will not have access to any discoverable material they are entitled to, and thus no risk of any harm to the plaintiffs at all if the Commonwealth returns Reed's property it has held for more than 2 years, let alone irreparable harm. In fact, Reed has already produced to the plaintiffs over 800,000 pages of documents the plaintiffs requested and has confirmed that she will be providing a supplemental response with additional documents. Although plaintiffs continue to characterize Reed's production as a document dump, plaintiffs specifically requested all documents exchanged in criminal discovery in Reed's prosecution and recently confirmed that they did in fact want each of those 800,000 pages. Reed provided those documents. Reed will soon produce supplemental documents in her own possession in accord with her Rule 34 objections, as well as documents from the Norfolk DA's office pursuant to her counsel's agreement with plaintiff's counsel months ago. 800,000 pages. Hold, please. Without support in any verified submission by plaintiffs or their counsel, plaintiffs baselessly suggest that data from the full cell phone extractions Reed received from the DA's office should have been produced to the plaintiffs directly by now. But the agreement between counsel, evidenced by the email chain attached to plaintiff's motion as Exhibit G, provided that the DA's office would provide to Reed's counsel all such extractions and that Reed's counsel would review them and produce non-privileged discoverable material to the plaintiffs. Reed's counsel received the DA's first production, which was extremely large and contained phone extractions, in mid-January. The plaintiffs received the same production except for these extractions, and despite their suggestion that Reed has caused further delay, they have yet to produce these documents to the other parties in the case pursuant to Rule 45. Reed will abide by the agreement her counsel reached with the plaintiffs months ago, as well as her standard existing discovery obligations concerning the phones and extractions in the Commonwealth's possession, and there is not a shred of evidence, let alone reliable or credible evidence, that she will not do so. Thus, there is no basis in the law or the rules and no need for the court to order Reed to submit any devices to full forensic examination. If a party to a civil case could obtain a temporary restraining order simply by arguing in an unverified motion that certain evidence is important, such orders would exist in almost every case. That is obviously not the applicable standard. Also tellingly, despite its extensive citation to Aidan Carney's publications and alleged conduct in its motion, the plaintiffs have not even requested from Reed communications with Carney. Of course, a good rule of thumb for parties looking for responsive data and documents is simply to ask for them in Rule 34 request before racing to court 6 months later to file an emergency motion for injunctive relief. As the court can see, the only request that could be interpreted to cover the communications plaintiffs describe in their motion is overbroad on its face. Reed objected to producing complete extractions of all her cell phones to plaintiffs in October of 2025. 4 months later, plaintiffs have still not contacted Reed's counsel to confer about narrowing this request or to challenge this objection, opting instead to burden the court and the other parties with an unnecessary non-emergency like this. Rather than spending time drafting yet another salacious pleading meant for public consumption, plaintiffs could simply have conferred with Reed's counsel or sent a separate request for production of communications with Carney pursuant to Rule 34, to which Reed would respond pursuant to the rules they did not and have not. Well, breaking from the document to say they probably thought they'd have a better chance in front of, I don't know, Judge Doolin or Judge Krupp. Finally, plaintiff's motion makes little sense On one hand, the plaintiffs argue that Reed should already have produced it. Should have already produced to it the extraction the DA apparently has from the phone in question. Page 6, and then footnote 1, which reads, it's unclear why the plaintiff believes the DA already has a full extraction of the phone when the Commonwealth's motion to search the phone in the criminal proceedings was denied. And Cosgrove has said many times in open court, he has not searched it. They haven't searched it. But on the other hand, they claim that the return of these physical devices will somehow lead to spoliation of evidence, which would be impossible if the contents have already been extracted. In reality, it will be easier for plaintiffs to receive discoverable information from these devices if they are turned over to Reed, a party to this case, rather than a third party, the Commonwealth. If plaintiffs were truly concerned about access to these documents, they would want them in Reed's possession, subject to the preservation obligations incumbent upon a party to civil litigation, as opposed to a third party that is not involved in this case. But that is clearly not plaintiff's goal. And they're saying, if you wanted it, you should have asked for it. And if you're saying that the Commonwealth has already extracted it, then it doesn't matter if they return her phones to her, because she can't destroy anything because they've already extracted it. But in reality, if she gets her phones back and extracts them herself, she's got to give it to you under the rules. For these reasons, the plaintiff's motion should be denied. XOXO. Karen Reed, by her attorneys, all of these people below. Damon Seligson, Aaron Rosenberg, those are the ones we hear from the most. And that was dated February 25th. And then the exhibits, which are responses to the first set of interrogatories, which is exhibit 1. I think we have read these before together because that is dated let's see when they responded to these interrogatories. Interrogatories are just a list of questions, and then you answer the questions. So it can sort of pare down depositions a little bit, make them a little bit shorter because the defendant has already responded in writing to the questions, the interrogatories. And these were responded to on October 18th of 2025. But wait, there's more. Next up, not to be outdone and always wanting the last word. The plaintiff replies to the opposition of Karen Reed's team. Stop. Go. Welcome. Welcome, Veronique. Sarah B. Creative, thank you for loving me and for being here for 19 months. I love you too. Danielle says, thank you. Great afternoon. Thanks for being here for 21 months. It's been a long one. My voice is going to need 2 days to recover, but Kimberly became a member. Welcome. Shervissa gifted 5. We looked at that. And Wendy says 6 months of laughs and calls for justice. Thank you for being here for 6 months. I appreciate you so much. Moving on to the reply from Mark Diller. This is my cursor on your screen, so please don't think it's a fly and break your TV and then send me a bill because I'm not paying for it. Crystal Justice says, hey, all cupcakes, check your notifications. Mine were shut off, but I never shut them off. Yeah, it's happening a lot. There's so much glitchiness with YouTube, and all the creators are complaining about it, including Queen Emily Baker. People are being unsubscribed. People are not getting notifications. People are being hidden from chat. People are being blocked. It is not your fault. It is a YouTube glitch. And they seem to be aware of it. They seem to be trying to fix it. But make sure you're still subscribed. It's free. Just hit the subscribe button. Enable your notifications and make sure also that you're notifications are enabled on your phone. Okay? Because it's going around. Thank you for pointing that. Here we go. Plaintiff's reply to defendant's opposition to plaintiff's emergency motion for temporary restraining order pursuant to Rule 65 to prevent the release of evidence. Give me 1 second to just flip through this to see how many actual pages it is. Well, Hall plays. I'll be right back. Hall plays. Okay, for some reason it says that it's 25 pages, but I think it's just like repeating. It seems to be only 5 pages, so we're good. Oh, look, mom promoted to Memair was unsubscribed, but fixed it. See, everybody check right now. Just check. Yesterday, what was it, yesterday or the day before? All English comments were being translated into different languages, and some people could only use emojis in the chat. It didn't happen to me because I wasn't live at the time, but it happened to a bunch of other people. And here it is. Plaintiff's reply to defendant's opposition to plaintiff's emergency motion for temporary restraining order pursuant to Rule 65 to prevent release of evidence. But it's not evidence, it's evidice. Sevedice. EVIDECE. Because some people, nobody uses spell check anymore. I don't know what it is. We must prevent the release of the evidice. Reed's opposition rests on either a fundamental misunderstanding or a deliberate overstatement of the relief that plaintiffs seek. Reed disingenuously paints plaintiffs as seeking a forced full forensic examination of Reed's entire phones provided directly to plaintiffs right this moment. This is simply untrue. Plaintiffs fully intend to honor their agreement with Reed's counsel concerning the phone's extraction produced to Reed by the Norfolk DA's office. Wait, what? Plaintiffs fully intend to honor their agreement with Reed's counsel concerning the phone extractions produced to Reed by the Norfolk DA's office. Pursuant to that agreement, and as evidenced by Reed's own opposition, such extractions are already in Reed's possession, and plaintiffs still await production of same. Yeah, but was that from the original phones? Hold on. Footnote 1 says Reed will soon produce supplemental documents in her own possession in accord with her written Rule 34 objections, as well as documents from the Norfolk DA's office pursuant to her counsel's agreement with plaintiff's counsel months ago. Reed's counsel received the DA's office first production, which was extremely large and contained phone extractions in mid-January. Okay. Notably, instead of working to provide plaintiffs with the purported supplemental records, Reed is expending her resources suspiciously fighting for the immediate return of the phones themselves, of which she does not need for any practical purpose. Oh, you mean like proving her civil case against everybody? Really? How can you really in good faith make that argument? How can you in good faith make that argument that she doesn't need her phones seized by Norfolk DA's office to try and persecute her for something. They've never extracted them, allegedly. How can you say she doesn't need them for any practical purpose? I don't know, except to prove her civil rights lawsuit, maybe? But your argument is because she has a new phone, she doesn't need them? Answer, it's in bad faith. Michael, they are her phones. That's all that's needed. And Judge Cannoni ordered the release of all of her property to her. Hello? She got her initial phone back and her car. Right. Isn't just using them as cell phones again a practical purpose? But she has a new phone, they're saying, because we saw her with a phone outside of court. So we know she has a new phone, so she doesn't really need them. The other Mary said, wow, I didn't know this was Stalinist Russia. Clamasu says Natalie wanted to be a star in this case. Thank you for loving my channel, Not That Carrie. I appreciate that very much. East Coast Thrift says, East Coast Thrift, it's her friggin' property. Christy says, not only this judge said give them back, but the other judge said give them back. Your bald assertion that she shouldn't get them back because she has another phone and because you're afraid she's going to destroy them, in my opinion, is not enough to insert yourself into a different case involving the return of her property. Plaintiff's emergency motion pertains to the communications contained on Reed's cell phones that are presently in sole custody and control of the Norfolk DA's office. Who knows if they planted anything on those phones or tampered with them in some other way. Upon information and belief, the Norfolk DA's office has not performed complete extractions. Okay. Too bad, so sad. Or any extractions of the subject phones, and may never do so if Judge Doolin allows Reed to immediately retake the possession of same. Well, then if she destroys evidence, you can criminally charge her with that because they really, really, really want to charge her with something. Courtney says, Mel, I bet they don't want to give them back because they don't know where they are. Right, but they're in the very secure evidence locker. They're in the very secure possession of the Norfolk DA's office. Right? Footnote 2, which reads, Reed also concedes such an extraction might not even exist yet. Okay. I mean, I could be wrong because I'm never going to bet on anything a Massachusetts judge would ever do, ever. But I don't think that a civil judge in Plymouth County is going to insert himself into a try to get my property back after acquittal case in Norfolk Superior in front of a criminal judge. I just don't see it happening based on your or Mark Diller's assumption that Karen's going to destroy the evidence because she may have said on a recording, you have no idea what's on my effing phones or something? Reed's commentary about the state of discovery is misleading and ignores the entire premise of plaintiff's motion. Plaintiff's request for production of documents does in fact encompass the data and communications contained within the devices at issue here. Footnote 3, which reads, it is ironic that Reed would complain about the breadth of the request when she is actively seeking 10 years of phone records from Massachusetts State Police troopers. Well, not all the troopers, just a former trooper who's been dishonorably discharged named Michael Proctor. Guess what? She got it. Doolin gave it to her today. So there's that. That was the first thing we read tonight. Whether plaintiff's request may be perceived as overbroad is a separate issue that may be resolved between counsel for the parties by simply narrowing the scope of the request. That's right, Scott McGinnis. Karen Reed's phones are on the butcher paper next to the microwave in the Norfolk DA's break room, likely under the coffee filters. Or they're just gone. They're just missing or lost. Is she looking for other troopers' phone extractions too, or just Proctor? And she got it today. It was ordered. Not just to be given to her, but also to be given to you, Mark Diller. You're getting it too, because you too served a subpoena on Proctor for those records. Hello. You wanted them too, and you're getting them because Judge Doolin said you could have them. Isn't that a little bit ironic? Because you wanted them too, and you got them. Yeah, they're in Proctor's drawer probably with all of the missing Sally Port video. Maybe that's where they are. Did you not want all 13 years of Proctor's phone extraction? As demonstrated within plaintiff's emergency motion, such cell phones contain material evidence directly relevant to plaintiff's infliction of emotional distress claims. I mean, if you're going to make that argument, what's good for the goose, right, is good for the gander. Karen's going to want Peg O'Keefe's phone for the reasons we discussed earlier. Paul O'Keefe's phones. We know some of what was in Paul O'Keefe's phones in the Facebook Messenger messaging. Wasn't a good look. Nancy Guthrie has the phones. Oh, man, poor Nancy. Where's Nancy Guthrie? Where is she? This is going to blow wide open, says Rich. Reed's own words belie this argument when she admitted, here it is. Here's what she said. I'm dead. I'm effing dead. Do you have any clue what's on the phone they took? I mean, let's just play devil's advocate for a moment and go to the Snark Tank chat. Anything else that Karen could have been mad about what was on her phone that she could be dead other than evidence incriminating her about what? About having killed John O'Keefe with her car? Anything else? Medical information? Oh, thanks. You sent me the audio, Emily? That's not what she says. Oh. Well, look at Emily coming in with the real information. I'm dead. I'm effing dead. Do you have any clue what's on the phone that they took? Plaintiff's motion, Exhibit J4. Should we listen to the audio? I think we should, but I'll keep that up so I remember. The plaintiffs merely seek an opportunity to safeguard the entire contents of the devices to be preserved in trust by an independent third party before the cell phones are returned to Reed or to the DA, depending on Judge Doolin's ruling. Once this is accomplished, the entire extraction, like all the third parties in this case, should be trusted. An independent third party. What happened to the taint team that they were going to? The taint team that they were going to get together to look at Aiden's phones, and they never did it. Could be anything, says Wendy. Could be family conversations, right? But let's listen to the real tape because Emily sent it to me, so just hang on. Once this is accomplished, the entire extraction can be produced to Reed's counsel for review of so you want the court to order Karen Reed can't have her phones back, but you can have them to give them to a taint team so that the taint team can then provide Karen with her own properties extraction. Okay, we'll see how far this gets. I don't know. I would never bet on any Massachusetts judge to do anything the way that any other judge would do it, or the way that is under the law. It's wild, right? Maybe she was making fun of Judge Cannoni. That's possible. Little Cupcake says, she said, I'm dead because she's afraid of them with good reason. And Big Old Dog says, She wiped the phone anyway. I mean, I have no independent knowledge of that, but that's what they seem to think that she said on the body cam, right? When they came to pick it up. They'll want Hank Brennan to run the team, says massive shenanigans. On February 27th, 2026, plaintiffs convened with Reed's counsel under 9C and proposed this protocol, and Reed's counsel advised that they would consider the proposal. In the event an agreement cannot be reached or disputes arise with respect to the existence or discoverability of certain information, a full extraction of the device data will be available for comparison and review by this court or a third party if necessary. In sum, plaintiffs only asked this court to maintain the status quo and preserve the cell phones in government custody. Well, do they really still not know where they are? Only until such time that the parties can be fully heard on the issue of preservation. Furthermore, there's nothing unclear about the critical need for the physical devices to remain secure in the exact state as they were seized in order to prevent immediate irreparable harm to plaintiffs. But the thing is, because there's probably no chain of custody on those phones, because we know that MSP doesn't do chain of custody and metadata, and it's not required. Who knows if those phones were tampered with? You can't assume that they're in the same condition that they were when they were seized from her in January of 2024, right? And that's why Reed probably wants her own experts to examine her own phones to further her claims that she's been framed. Reed claims plaintiffs have not presented and cannot present any evidence whatsoever of discovery malfeasance by Reed that would support their motion. To the contrary, plaintiffs already provided the court with body camera footage from a 1/24/24 search warrant execution, during which Reed took affirmative steps to factory reset a cell phone, ostensibly wiping all data and information contained intra before providing it to investigators. Okay, so then there's nothing on it. If you're accusing her of wiping the phone, then there's nothing on the phone, right? Then why do you need the phones? This is not some run-of-the-mill fishing expedition. The circumstances of this case are unique and plaintiffs' concerns are warranted. The cell phones plaintiffs seek to preserve contain crucial evidence in support of their claims. Well, no, they don't, because you just said she wiped them. Which is it? Given the history here, plaintiffs cannot be expected to sit back and blindly trust that Reed and her team will unilaterally identify and preserve all potentially incriminating evidence on Reed's devices, let alone voluntarily produce the same. There must be guardrails in place to protect the plaintiff's rights and the integrity of the process. Moreover, it's notable what the defendant does not say in its opposition. Remarkably, in her opposition, defendant Reed fails to assure plaintiffs or this court that she will ensure that all information on those phones is preserved. Reed offers only half-hearted assurances regarding the preservation of this evidence, stating that plaintiffs will have access to discoverable material they are entitled to, and that Reed will comply with her standard existing discovery obligations with respect to the phone. Regardless of these representations, a finding of potential malfeasance is not necessary for a ruling in plaintiff's favor. The moment those devices are removed from Faraday protection / secure evidence holding. Wait a second. Oh, come on, Diller. What makes you think they're in a Faraday bag? Or even securely being held in any evidence room anywhere? They're in a drawer. Maybe they're in Proctor's drawer. Maybe they're in somebody's house. Who knows? That's funny. The moment those devices are removed from Faraday protection / secure evidence holding, they become vulnerable to alteration. Oh, you mean like that Sally Port video that was inverted? Any normal or innocuous use of the phones may overwrite crucial information and metadata contained intra. Well, do you remember what the Commonwealth did when they had Karen Reed's first set of phones? And you can correct me if I'm wrong, because if I'm wrong, I'll say so. But I do believe that all of the location data was wiped from Karen Reid's cell phones while they were in Commonwealth possession. They seized her phone January 29th of 2022, same day they seized her Lexus, same location. And her location data was wiped from that phone in April of 2022. Karen didn't even have her phone then. You know who did? It was in secure evidence holding. Because of the location data still existed on her phone. It would have shown where she was at certain times. So it's really funny that you think that. Or maybe it's just naive, or maybe you just don't know. Because you're not as up to speed on this case as all the people in my chat are. Diller sat on the O'Keefe side during the second trial. Did he not see how poorly the evidence was handled by the Commonwealth? Exactly. 112-521. Shop right bag. No, Stop and Shop bags everywhere. Solo cups. Maybe it's in a solo cup. And a Stop and Shop bag. In the Sally Port. That's my guess on where it is. Or they are. There's 2 phones missing, right? The phones should remain in the exact state as they were seized until the plaintiffs have an opportunity to be heard on the matter. With respect to Reid's procedural argument, the plain language of the rules suggests that an affidavit or verified complaint is required for a judge to grant a TRO without written or oral notice to the adverse party or his attorney. Footnote 5. A temporary restraining order may be granted without written or oral notice to the adverse party or his attorney only if it clearly appears from specific facts shown by affidavit or the verified complaint that immediate and irreparable injury, loss, or damage will result to the applicant before the adverse party or his attorney can be heard in opposition. Here, we didn't do this ex parte. Karen Reid's attorney was present at the criminal hearing on Thursday when plaintiff's counsel first learned of the hearing and called in from the airport. Oh, he was at the airport. During which the court ordered plaintiffs to file their papers on Monday. Oh, boo, bummer. Bummer. You went out where you were going on vacation and you had to file papers by Monday. Plaintiff's counsel also copied Reid's counsel on the filing with the expectation that it would not be opposed. Even if plaintiff did not comply fully with the rules, such argument promotes form over substance and should not deter this court from exercising its inherent authority to control evidence. Plaintiff's motion here sounds in equity. Yes, fairness. Had Reid's lawyers given plaintiff's counsel the courtesy of advance notice regarding the motion to return property, you're not entitled to a courtesy call on that. This has been going on for over 2 years. She's been trying to get her property back. You're not a party to that action. You don't have any standing to argue in that action. And they didn't owe you a courtesy call. Had Reid's lawyers given plaintiff's counsel the courtesy of advance notice regarding the motion to return property, plaintiffs would have served their motion in accordance with Rule 9A. Instead, plaintiffs were left no choice but to seek this court's intervention in emergency fashion because Reid chose to proceed in a separate sealed criminal matter, and plaintiffs learned of the need for such motion just 2 business days before such motion was due to the court. Regardless, Reid cannot claim any unfair prejudice here from the absence of an affidavit, whereas they were given notice of plaintiff's motion. And plaintiff's exhibits clearly demonstrate the necessity of a temporary restraining order in this particular instance. If the court deems it necessary, plaintiffs will provide an affidavit forthwith. XOXO. Mark Diller. Filed on the 27th, which is today. So look at us being on top of the papers that were filed just today. And then I don't know why I've got like 5 copies of it in one file, but will the judge in Plymouth intervene and demand Karen Reed's property not be returned to her because of Mark Diller's fear that if it is, she may destroy it. Emily C. says, and she's always right because she's wicked smart, you'd think the O'Keefes would be this aggressive about finding out who the 3 to 5 DNA contributors were to the stains on John's clothes. Right. You would think that, right? Wouldn't you want to know? What will the judge do? Your guess is as good as mine. Facts, Emily. Okay. Let me just listen to this for a second. Oh. I can't open this on my system. Hold on, let me see if I can. All right, I'm going to warn you because there's it's only a 7-second clip. But I don't know if it's going to let me play the audio on my system here, but we can try. We could try. Oh, please.
You brought me in the fucking mud with Tully. Again.
Yeah.
Fucking again. Do you have any clue what's on my phones that they took?
Do you have any clue what's on my phones they took? Does she say I'm dead? I didn't hear her say I'm dead. Wait, can you hear it? I'm going to play it again.
And then you brought me in the fucking mud with Tully. Again. Fucking again. Do you have any...
Again. Effing gen. That's what it sounds like to me. Again. Effing gen. That's what it sounds like. Again. Effing gen. Not I'm dead. To me. Hold on, I'm going to turn it up in my earbuds. Effing gen. Listen.
And then you brought me in the fucking mud with Tully. Again. Fucking again. Do you have any clue what's on my phones that they took?
Yeah. Look at Emily C to the rescue. It's not what she said. She said again. Effing again. Not I'm dead. Do you have any idea what is on my phones that they took? You heard it, right? Guess Mark Diller didn't hear it. Thank you, Emily. Everybody thank Emily and go subscribe to her on YouTube and all the things. That's what it sounded like to me. Oh. Thank you. Wasn't me. 1952 for your very generous $50 super chat. Thank you. Thank you so very much. You're very kind and generous. Oh, please. That was very sweet of you. Not that Carrie from Canada says 2 lives in one day. I donate when I can, but you are very importantly picking up the wildest injustices. How could anyone not like you? Love from Toronto. Oh, thank you. You're very sweet. I don't know. Because I think that John O'Keefe, I know that John O'Keefe is not hit by a car and a car didn't hit John O'Keefe. Really, that's the main reason. The main reason. Josh says, does the Fourth Amendment actually mean anything in Massachusetts? No, not really, no. Massachusetts is where your constitutional right to go to die. You know that, Josh. You've been here long enough. You've been here for 5 months. Thank you very much. Zoe says, thanks for focusing on justice for all. I love you with all my heart. Oh, no, I love you more. Thanks, Zoe. Josh says, honestly, I bet Norfolk DA did extract the phones and found nothing. Why wouldn't they? But they don't want to admit it. Thanks for your 5, Josh. I mean, I think they're saying that they don't have her passwords And we know from other cases that if you hook it up to Gray Key, it could take years, right? It could take years for them to jailbreak it. So I don't know how they even went to a grand jury to try and indict Karen and Aiden without Karen's phone extraction, because what other evidence did they have? Thank you, Josh, for your 5. MCLM says, what in the Bob Ross is happening? Ms. Holmes says, in my opinion, Diller hates Karen Reed just as much as that big case Mike attorney who was a guest on Court TV and Julie Grant. Bunch of sad sacks they are. LFG. Thanks, Ms. Holmes. B5. Gigi's here. She's got your back. And she gifted 5 memberships. Thanks, Gigi. Strong Leg says, all I hear is the plaintiffs. Want, 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 want. We don't have a case, so we need her phones. Thank you, Strong Leg. The phones are secure in the wait, how did she say it again? Garage. Thanks, Gigi. Strong Leg said, I said this in trials 1 and 2. The feds move slowly. They may now be waiting for the civil trials to conclude before they step in. The feds know a lot that we don't. A lot. Oh, sweetie, no, gifted 5 memberships because she's amazing. Strong Leg again, coming in with another hot 10 spot. All this Massachusetts Commonwealth corruption and cover-up across so many cases is pissing me off, and I'm not taking it anymore. Therefore, I vent with $10 super chats, Mel. I love it. Pokey says, yacht today, Diller. Yacht today, Diller. Thanks for being here for 12 months. You're awesome. Mom promoted to Memair says, someone send Diller a Groupon to Miracle Ear. He needs it. I mean, if they sent the judge a copy of that, I'm sure the judge can hear it if we can, right? I mean, I'm just saying. Let's see. I mean, you guys are sending me a lot of documents under that case number, but that's not what I'm asking for. I guess you're not picking up what I'm laying down. What I want to know is under what docket number these cases are actually filed under in mass courts, unless it's sealed, and that's why we just can't access it. I don't know. The phones are keeping the trolls distracted, says Sarah. Without the phones, trolls will start looking at the McCabes, the McCabes and Alberts. Okay. Looper says, hit by a car is a misnomer. It was a swipe that combined with, I think that's supposed to say inebriation, resulted in his demise. O'Keefe's should win the suit when the alternative lacks any substance. As a civil litigator and injury attorney, I have handled thousands of car accident cases, thousands of them, including pedestrian versus motor vehicle accidents. Never have I ever seen a case where a pedestrian is hit by a car and has no injuries below the neck, except what looks like an animal attack of some kind to the right arm. If you believe that John O'Keefe was swiped by the Lexus going something like, I don't know what their last number was, 24.2 miles an hour, and struck him where, I'm not quite sure, you're saying that he was struck on his arm. His elbow would have been shattered at 24 miles an hour. And so, I mean, as much as I hate to disagree with you, because you seem like a really nice person, John O'Keefe was not hit by a car. A car did not hit John O'Keefe. And physics, science, medicine, I'm sorry that you don't want to face the facts, but those are the facts. Oh, maybe that was true for Paul. Maybe. Maybe, Mitchell. Never have I ever. Never have I ever. It's the trolls. And this is we're on a 5-day hold here. We're on a 5-day hold. So whatever trolls are coming in, they have been so tenacious. They have waited 5 days. They have changed I'm not saying that that person was a troll. They have waited 5 days after changing their YouTube handle to come in here and troll me. Because they're nothing if not patient and tenacious. Placid Wave says, hi, Melanie. First time listening live. You're so good at your job. Loving this. Thank you so much for your 5. I appreciate you so much. Final thoughts, questions, comments, and concerns before we leave. Oh, that's right. That's right. Make mine in Minnie says, Welcher said he never said anything about 24 miles an hour. She was also found not guilty. Let me explain something to you also about plaintiff's work. When you're a plaintiff's lawyer, because I was for 3 decades before I retired to come here and spend time with you. Plaintiff's lawyers, and I'm going to say this again for a little bit louder for those in the back. Plaintiff's lawyers take cases on contingency, which means we don't get paid unless and until you receive a settlement or a verdict, and the verdict is collectible. If there is a settlement, then typically in New York, it's 1/3 of the recovery goes to the attorney, 2/3 go to the plaintiff or the client. Also, fun fact, it's tax-free money. The plaintiff, the only tax-free money you'll ever truly get because it's a personal injury settlement. Also, the plaintiff's attorney fronts all of the expenses throughout the case. Plaintiff's attorney fronts it all. They pay for everything, experts, depositions, postage, video depositions, medical records, all of the things and costs during both pretrial and trial, all of them are fronted by the plaintiff's lawyer. At the end of the case, the plaintiff's lawyer gets their expenses back, and then it goes 2/3 to the plaintiff, 1/3 to the attorney. And that is why plaintiff's attorneys make a really, really good living. Think about it. You settle a case for $9 million, you're getting a $3 million fee plus your expenses back. Win-win. That's why plaintiff's attorneys don't take cases that are losers. Because why spend your time on losers? Winners focus on winning, losers focus on winners. Remember? Plaintiff's attorneys do not bill by the hour. And they don't collect any money until, if and when there's a settlement or a verdict. I'm not quite sure why Mark Diller took this case. Maybe he thought it would be a quick settlement because he filed the lawsuit with 6 months left on the statute of limitations. And that was before Karen's second trial. After the second trial, she was acquitted of anything having to do with her car hitting John O'Keefe. He may be ruining the day that he ever took this case because based on how much discovery they're going to have to do and all of the expenses that he's going to have to front, it's going to be hella expensive. So there's that. Grasping at wet paper straws to try and find any evidence that is going to show that Karen Reed hit John O'Keefe with her car is like he thinks it's going to be found in her phone because he's not going to be able to find an expert short of Judd the Dud Welcher to come in and say that John O'Keefe was hit by a car. I'm sure he's shopped it around as any good plaintiff's lawyer would do before taking a case. And I don't think there's going to be an accident reconstructionist on the planet that's going to want to step into this case and come in and say that John O'Keefe was hit by a car. Just not. Vicky Sullivan, why are you spamming the chat with your constant, repetitive comments? You need to take a little time out. Yeah, What's the over-under that Diller walks away from the case? He could make a motion to be relieved and say, listen, I can't afford to prosecute this case anymore. You know how much 41 depositions are going to cost? You know how much the transcripts from that are going to cost? The videographer? Not to mention he's not getting paid by the hour. So all of the time that is going to be spent on just depositions alone? I don't know how big of a firm he has. I don't know how many lawyers are working in his office. This is going to consume him for the foreseeable future until this case goes to trial. I mean, he could withdraw, but then they'd have to find another attorney to represent them. Music to My Soul says, I've been streaming the Corey Richards trial, but I hate to miss your streams. Hoping to catch up on replay this weekend. Love you too. Love you too. Thank you for your 5. All my opinions. All my opinions. Oh, Jellybean says, Diller was my attorney. I was rear-ended, required neck surgery, pushed me to go to trial, denied any settlement offers, and ended up losing my case. And I got a $3,000 bill from the defendant's attorneys. What? Wait a second. What? Well, I don't know how you could lose a case in which you were rear-ended, because that couldn't have possibly been your fault. Well, there's a Google review for Mark Diller right there from Jellybeans. Also pointing out to you that I'm a New York barred attorney, and Massachusetts has different rules and different threshold requirements for injuries when it comes to car accidents. But that's wild. I don't know what kind of settlement you were offered, but I'm really sorry that happened to you. And you had a laminectomy, some kind of spinal surgery, or discectomy. Those are high-dollar cases if you can prove that it was from the car accident. Sorry, Jelly. Everyone feels sorry for you, Jelly. Wow. Yeah, I'm not sure if she's saying that she declined the settlement offers or that he did. Scott says, an O'Keefe civil suit against the House defendants or the Haas defendants and the DA/police would make far more sense. I've been screaming this from the rooftop, Scott. You know I have. And I said, listen, Diller could have a potential malpractice case against him if he doesn't sue everybody and let the jury sort it out. Problem is, statute of limitations has expired for all the Haas defendants and also for the municipal defendants. And to cover his own ass, he must have had the O'Keefes sign off on the fact that maybe they didn't want him to sue the Haas defendants, MSP, Canton PD, Proctor, BUKHEKIK. Otherwise, it's a recipe for malpractice. Sue everybody and let the jury figure it out. The more pockets, the better. It's a problem. All right, my friends, let's see. Anything else here? Better get out the blue paint. It says on top, thanks for your super stickers tonight and super chats. Reality with Krista Marie says, I think it's disgusting what state is putting Peggy through 2 trials and still going, knowing it's an unwinnable case just for their ego. Thanks for your 5. Here for Humanity says, Mel, I have a gift for you. Where can I send it? I don't have a place where anybody can send me anything, and I don't need your gift. I mean, I don't expect anybody to ever send me gifts. But thank you very much for even thinking of me. I appreciate that so much. And Nay says, when Diller talks, I think dry eyes guy. I don't know. All right, you guys. Thank you to the Goodmans. Mr. Goodman, Brian Goodman, 320 says, thanks for the live Friday night date night. They watch me on their date nights. I don't know why, but they do. We love the Goodmans. Thank you for the Venmo. And then his wife will have a competition with him. And her name is Dee. I love you guys. All right. Thanks, mods, for doing it twice today. Double duty. Double duty. We'll see what happens with this motion. It's creative, that's for sure. Karen Reed should not get her phones released to her because she may destroy them. But again, Karen Reed already wiped her phones, they say. And then they completely misquote what we just heard in the audio. She didn't say I'm dead. She said, effing again. Go back and listen to it again for yourself. Please hype the video when the video is over. It helps the algorithm. Please, comment respectfully below the stream after it's over, and do all the things. And thank you to the moderators so very much. I love you with all of my heart. If I don't see you soon, I'm going to die. Make sure all of your notifications are set and all of the things. And this was only 2 hours and 10 minutes, but it felt like it was 4 hours because my voice is shot. Stay cool, stay kind, stay classy. Above all, stay safe. Thank your moderators. Tip your servers. I will see you guys again real soon. Justice for Karen Reed and John O'Keefe. Peace out. I love you guys. Bye.